So, you know what is guaranteed to ruin your day? Email from an attorney saying that your website is out of compliance and your small business owes money because it's causing harm. So, opportunistic lawsuits, they're nothing new. But lawsuits against small businesses around CIPA, or the California Invasion of Privacy Act, that is something new. So, today, we're going to talk about what CIPA is and why you should care. I'm Erica Dickstein, and I am with Spring Insight Marketing, and I am so delighted and excited to welcome Donata and Hans here with me today to chat about this. Can you guys introduce yourselves?
Sure. So, hi everybody. My name's Donata, and I'm a attorney licensed in Illinois and a certified information privacy professional. And I guess on that vein, we're not providing legal advice today. I'm the president and legal engineer of Termageddon, an auto updating privacy policy generator. I'm also the chair of the American Bar Association's e-privacy committee, a member of the ABA Cybersecurity Legal Task Force, and I'm a ABA representative to the United Nations.
My name is Hans. I am best known these days as Donata's husband. Prior to I'm one of the co-founders of Termageddon as well. Termageddon is the auto updating website policy solution we provide to website owners. And prior to Termageddon, I've run a software development company, a web design company. I have a lot of experience in the tech side of things.
Awesome. Termageddon, a partner with Spring Insight, I will add.
That's right.
So let's get into this conversation. What is
Sure. So CIPA is the California Invasion of Privacy Act, and it was created a long time ago, even before Google was in existence, to basically protect residents of California from third parties eavesdropping on their calls. And at the time, it was calls on landline phones. And what's really interesting is that this law has been reinterpreted through a number of court decisions to apply to websites. So courts have said that when a user interacts with a website, that's quote unquote a communication with a resident of California and a website. And any third parties that intercept that communication, so for example, like Google Analytics knows which pages you clicked on the website, or Facebook Pixel knows what ads you clicked on or what pages you clicked on. They consider that to be an interception of a communication between a resident of California and a website. So CIPA allows consumers to sue businesses directly for violations. So because of this reinterpretation by courts, we've seen dozens and dozens and dozens of lawsuits being filed in the state of California for tools such as IP intelligence tools, Facebook Pixels, analytics, live chats, any of that kind of stuff.
So yeah, and the reality is small business websites use tons of free third-party technologies to give their website visitors a great experience and also understand how someone uses their website. And just to reiterate in what I consider a little bit more layman's terms, like websites use third-party technologies all the time. And unfortunately, if you get traffic from California visitors, you may need to get their consent first prior to letting those third-party technologies load on the website.
Yeah, I think that's what the most interesting thing, Donato, was even when I was investigating for this video, I was thinking, oh, this new, I had in the verbiage, this new law. And as I was like looking at it, I was like, wait a minute. This is not a new law. This is actually a like chips era, law from that is a reference that you as much younger people may or may not actually get. But that was from a long time ago. And I think also, Hans, what you said is super relevant about this being so small businesses use so many of these kinds of technologies. And for a lot of them, they don't even know. They might have had somebody set things up a long time ago. They're not thinking about Google Analytics or these various pixels that are associated with it. Donata, you started to get into this, but why this is becoming a story right now, why we're talking about it right now.
Well, the issue is that in the United States, we don't have a federal privacy law that covers information commonly collected through websites like names, emails, phone numbers. We have laws for healthcare data, financial data, or children's data, but not things like analytics or pixels or IP intelligence. And because of this lack of laws, we have these states proposing and passing their own laws. There's like this whole patchwork of different rules, but there's really no one set of rules to follow. And what consumers are doing is they're saying, I don't want this anymore. I don't want to be tracked by tools that I have no control over. I don't want these companies to take my data and share it with third parties. And this law was found by a couple law firms, and they decided to say, well, there's no federal privacy law, but let's see what happens with this one. Let's see if we can turn this into something that can help consumers protect themselves in theory, right? So they started suing businesses, and a couple decisions came down saying that, yes, these tools violate CIPA. And that kind of opened up the floodgates, because this is a law where consumers can sue businesses directly. So it's very lucrative for the law firms to sue businesses, because you can make a lot of money this way, right? Pull a list of websites that have these tools and just write these lawsuits, and they're very, very similar. Companies are getting very, very similar demand letters. Maybe the company names changed, but not much has changed. And I hate to say it this way, but it's kind of an easy way to make money as a lawyer, unfortunately. I think in some areas it makes sense, like healthcare websites sharing healthcare data with Facebook Pixel. But we've seen a lot of really small businesses like that create patches, or that provide like interior design or something like that, where the data is not really sensitive,
and they're not even located in California. And that's a good thing to remember too. Privacy
Yeah.
laws protect people. Privacy laws don't care about where your business is located. What matters is whose data are you collecting. And sure enough, if you're getting traffic from California, you may be subject to the.
That was exactly my next question. Is I'm a small business. I am located in beautiful Bethesda, Maryland, where my office is right now. So I take it, based on what you just said, Hans, that doesn't clear me. I don't have to say, okay, see you later. I guess I'm just going to ignore this.
Unfortunately, no. Privacy laws protect people. They don't care where your business is located. So if you're getting traffic from Californians and you use third-party tracking technologies, you absolutely could be subject to these lawsuits.
A fun tidbit of CIPA is that you don't even have to be a business. So CIPA actually applies to individuals who are intercepting these communications as well. So I know that there's a lot of solo people who may have never even formed an LLC or a corporation or anything like that. They could still be sued, because CIPA does not specify that you need to be a business to be sued under that law.
Can we go a little bit back into something Hans just said, which I think was very interesting, which was if you're getting traffic from California. So what does that mean exactly? Does that mean, how does this opportunistic attorney know whether or not I'm getting traffic from California?
So I think that what's happening here, so it's basically a person from California visiting your website and being tracked through one of those tools. So a great example would be they have a list of websites which you can find that use Facebook Pixel, for example. So they have a resident of California visit that website, get tracked by Facebook Pixel without their consent, and then here's your lawsuit.
So that's a great
And what's
point. I mean, they have that California resident, right? That California resident. So even if you are, what's crazy about the way you're saying this, you talked about like a decorator, right? A decorator might be a decorator located, or a home decorator located in, let's say, I don't know, Nashville, Tennessee, who services people in Nashville, Tennessee. But if they're using this Facebook Pixel and are on this list, a California resident who goes there, paid for by the opportunistic attorney, they are subject, because they are a California resident. And as Hans said, it protects the individual, not the state.
Yeah, that's right. That is the situation that we're in right now. Do I think these attorneys probably will go over after like easier to target groups? Yeah, I would think so. Like if I was an attorney, I'd be like, all right, well, I'm going to target the medical industry first, then I'm going to target, any like fringe websites. I don't know. That's how I would do it, because I feel like that would just give me even more of a case. But the reality is anyone could send a demand letter, and there's some serious teeth to these demand letters that are being sent out.
Well, what's interesting is that, I, as an attorney, I would be going after businesses that I know would be able to afford to pay for this lawsuit, right? Like usually what happens is they send a demand letter saying, hey, a California visitor was tracked by your website without their consent. You need to pay us $20,000 or we're going to sue you, right? And even if you don't pay and you go to court, it's going to cost you thousands and thousands and thousands of dollars just to defend that lawsuit. So you would think that you'd be going after people who can pay that $20,000, right? To whom it's not a big deal. They'll give you the money and move on. But we've seen a lot of really, really small businesses getting sued under this who are like, well, I can't pay this. Like, I would have to declare bankruptcy if I had to pay this or if I had to go to court. So it doesn't seem like they have a true strategy of going after the people who can pay the most. They're not going after the biggest companies. I mean, those companies are getting letters too, but not as much. But they're also going under small business, which I think is really interesting. That's not necessarily the strategy that I would take if I was trying to get paid more, but that's what's happening.
Well, that's crazy. And also, of course, it's not one entity. It can be all these different attorneys. So it's not even necessarily like they're working together. So, okay, wow, that is a lot. So I'm sure everybody who's watching this is like going crazy, like, oh my God, how do I protect my business? How do I get CIPA compliant so that I don't have to, as Donata just said, go to court and fight this crazy lawsuit?
Yeah, no. So there's two routes. Route number one, which I think we're going to see more and more of as the years go by, which is don't use third-party tracking tools. When your business can afford to not track your website visitors for analytics purposes or various other purposes, like that's the best step you can take because there's nothing to combat when you're not using third-party tracking tools. And I'll give you some examples. There are many free analytics, privacy-friendly analytics tools out there. There's privacy-friendly security tools out there. You know, Facebook Pixel, if you run Facebook ads and then you put Pixel on the website and the ad campaign doesn't really work out that well and you shut down the ad campaign, remove that Facebook Pixel. You don't want to just sit in there. I've had so many people contact us telling us they forgot that they had Facebook Pixel even on the site. It was from a campaign years ago. And so the first step, and if you can take it for your business, just don't use third-party tracking technologies.
Same thing as well, if I can interject real quick, sorry. It's like analytics tools. You know, we have so many businesses that have Google Analytics on the website that don't even know how to access their analytics data, have never accessed it, or don't even know what to do with it once it's been accessed. If you're not using these tools, stop using them and, you know, take them off of your website because all they're doing is putting you at risk.
So that's route number one.
Super interesting.
Yeah. So route number one, just remove everything. But then there's all businesses that have to track their users for marketing purposes and stuff. And that's great. It's totally understandable. It's just that for your website visitors from California, you need to block all third-party technologies and get consent from the visitor first. And therein lies a cookie banner or cookie pop-up. Everyone has a different terminology for it, or a consent management platform. You add a banner to the website that blocks all third-party technologies, and only after a user clicks accept, meaning they've given an explicit action, they've consented to their data being shared with these third parties, does the website allow those third-party scripts to load. So a good cookie consent banner, a cookie banner is not just a little statement, hey, we use cookies and deal with it, and there's just a giant OK button. That's not compliant with CIPA, let alone any privacy law that requires consent. What you need is a cookie consent banner that will block those third-party technologies, and only after the user clicks accept all do those third parties get allowed to load and track that individual. And now you have the right to run your campaigns to people in California, make your website visible to people in California. That's how you address CIPA. And let's be real, that's also how you respect your website visitors' privacy rights. I know that this lawsuit is frustrating in the sense that it's not fun to get a demand letter for $50,000. I mean, I get that. And it's extremely frustrating. If there's any silver lining here, we have an opportunity to respect the privacy rights of our website visitors. Let's bring that forward and move forward with that direction.
Awesome. So my last question is, how do CIPA and GDPR relate? So if you are CIPA compliant, are you GDPR compliant? And if you're GDPR compliant, so are those two different, or how do those sort of, I know there's some similarities, but it seems like just based on your head shaking that there are also some differences.
I think it's a little more complicated than that. So I think there's a couple parts that go into compliance. So one of the parts where CIPA and GDPR would overlap is obtaining consent prior to tracking people. So just like CIPA, GDPR also requires you to obtain consent prior to tracking people for Google Analytics or Facebook Pixel, for example. right? But they also diverge in the sense that with GDPR, you also need to have a compliant privacy policy. You need to have a specific legal basis for processing data. You can't transfer data in and out to other countries, without proper documentation. You have to offer people additional privacy rights and things like that.
Got it.
So a tiny component overlaps, but otherwise they do not overlap.
Sorry, it's also important to know California doesn't just have CIPA. They have CalOPA, which applies to any website owner who's getting as little as an IP address from a website visitor. They also have CPRA, formerly known as CCPA, which tends to only apply to larger type businesses that pass certain revenue or data processing thresholds. So just remember, a lot of people are like, oh, I comply with GDPR, therefore I'm compliant with all privacy laws. And that's unfortunately, I wish it was that easy, but it's not. Every privacy law loves to be special in their own way. And we as website owners need to find out which ones apply to us, what disclosures we need to make in our policies, what type of consent we need to capture from our site visitors. The reality is the website industry is getting regulated. We can choose to keep our head in the sand and pretend this stuff doesn't exist, or we can get in front of it, respect our website visitors' privacy rights, and embrace these privacy changes and demonstrate that respect to our website visitors.
Yeah, I mean, I would much rather lose some analytics data or get consent for tracking instead of getting one of these demand letters or be served by a lawsuit. Like, I know it's painful for people. Oh, I have to remove Google Analytics now, or oh, I have to remove IP intelligence tools, and this is so ridiculous. But it gets a lot more ridiculous when you get that letter. It gets a lot worse.
Yeah, no, absolutely. Well, thank you both so much for joining me. Thank you, everybody who has joined us. I hope that everybody got a lot out of it. I know I am, like, my head is rushing with things I would say to find out whether or not my site is, but I know whether or not my site is. So for everybody watching, if you've enjoyed this, please subscribe to our channel. We put out new content every single Tuesday that is just hopefully as educational and informative as this. Donata and Hans, why don't you tell us how people, having now heard of your brilliance and how you help people combat this, how can anybody watch this get in touch with you?
Yeah, so we run Termageddon together. Termageddon, it's like term age Don with two D's for Don. And so, we offer policies and consent solutions for our website clients, and $119 a year, auto updating website policies. We monitor these changes, notify you of changes, and keep your stuff up to date. And yeah, CIPA certainly is a great example. Although it's a 30-year-old law, but out of nowhere, these lawsuits have occurred and been reinterpreted for websites. So yeah, feel free to check us out at termageddon.com. And in the footer, there's all our social media links as well.
Yeah, and we also have some blog posts on CIPA too that you can read if you're interested in learning more.
Awesome, thank you. And obviously, the that URL is going to be in the description of this video, so people will be able to easily find Termageddon and Donata and Hans. And as a very happy client of theirs and partner, because we use it for a number of our client websites, I think it is such a no-brainer for agencies, and also just for individual businesses. So for anybody still watching, if you want a new website or marketing campaign that probably is going to have Google Analytics on it, unfortunately,
not a bad thing, just get consent,
but will then have consent built into it, I hope you'll get in touch with us. Our URL is springinsight.com, which will also be in the description of this video. Thank you very much, everybody.